Mr. Shadd, would you please identify yourself for the record? Name and address.
Corey Shadd, 725 Middle Road, Minden, Louisiana, 71055. Thank you, Chairman Garfello, and the members of the committee. I come before you today on behalf of the citizens of Louisiana who are no longer able to speak for themselves due to death or serious injury from medical malpractice. My grandmother, Phoebe Shadd, was in fact affected by the negligence of the medical professionals who were entrusted with her care, both her physician and the nursing home in which she spent the last 4 months of her life. In these next few minutes, I'll try to share with you her misfortune and unfortunately how her case will never receive closure due to the current statutes in place with the Louisiana Medical Malpractice Act. My grandmother passed away in October 2013 from what we now know was an infected diabetic ulcer on her left foot. It was improperly diagnosed first as a staph infection, then as a brown recluse spider bite, however was never correctly diagnosed until after her death. The nursing home was responsible for changing her dressing on her foot and ensuring it was healing. The nursing home informed the family that her foot was healed. However, about a month after the foot was deemed healed, the family was told on one of their daily visits that Miss Shadd needs to be taken to the doctor immediately, as her foot would need to be amputated. The nursing home said the spot on her foot came back over a 24-hour period and was severe. When we arrived at the doctor's office, Miss Shadd's foot was, for a lack of better words, grotesque. The bone of her big toe was exposed, and the bottom of her foot was completely black. There is no possible medical way this happens in 24 hours. It's a scientific proven fact. When the family asked the doctor what exactly this is on her foot, the response was, "It doesn't matter what it is, her foot just has to come off." Due to low hemoglobin levels, Miss Shadd's surgery was postponed until after the weekend. Unfortunately, Miss Shadd passed away the night before her surgery. After continual finger pointing from both Miss Shadd's physician and the nursing home, the family moved on to deal with the grief of losing a mother, grandmother, sister, and friend, all while feeling the guilt of could we or should we have done something differently to help her. We entrusted her to the care of trained medical professionals, yet failed to provide her quality care. It was not really until the following year the family was able to really gather the thoughts and concepts of filing a case against the physician and the nursing home. The case was not being brought forth for monetary gain at all, rather holding the parties responsible for the inability to properly diagnose Miss Shadd's ailment, to the obvious lack of care she received, and to help prevent it from occurring to someone else in the future. In March 2014, we sought the advice of a lawyer who sent Miss Shadd's medical files to 3 medical professionals, a surgeon, a nurse, and a physician, all of which agreed there were signs of negligence not only on the care she received from the nursing home, but the multiple accounts of the physician's inability to properly diagnose the issue and the plan of care. The lawyer built a claim around the physician's case as he felt we had a better chance of winning the case with the amount of documented evidence we had on the physician. With the cost of medical malpractice cases, he advised we must go with the one we had the best chance of winning. The claim was filed with the medical review panel and the waiting began. This is when I noticed the time frames that are required of the claimant is very stringent, but the stringency of the medical review panel is pretty much non-existent. Even though there is a clause allowing the clock to stop on the 3 years you have to file a case in the court system, the panel literally can take as long as they want to render an opinion, thus dragging out the case for the families to have to endure. Through the process, I've talked with several families, law offices, and concerned citizens who have dealt with this process. Some have waited over 3 years to receive an opinion from the panel. In our case, we had to wait about 15 months. The panel came back with an opinion in favor of the physician, stating the physician had adequately treated the patient and followed applicable plans of care. I find it amazing the doctors of the panel were miraculously able to diagnose Miss Shadd's ailment through a couple of pictures, a few pieces of paper, as a diabetic ulcer, something her physician wasn't able to do for the 4 months she was alive in her care, and thusly improperly treated. This is when I realized the medical review panelists are required to be from the same specialty or class as the defendant healthcare provider. When I looked further into the physicians who sat on the panel for her case, 2 were from the same area, one graduating from the same class as the physician in question. I would like to know how they're supposed to give an unbiased opinion on someone they work with, went to school with, live nearby, are friends with, etc. I also noticed while reviewing the minutes of the meeting, they met and discussed Miss Shadd's case for 30 minutes. In 30 minutes, they were able to diagnose her ailment, come to the conclusion no wrong had been done by the physician, even though 2 out-of-state physicians who reviewed the case stated there was significant evidence of neglectful practice, and basically allowed the physician and nursing home to get off free without any repercussions for their actions and move on to do something similar to another person in their family. We received notice from our lawyer of the opinion, and he said he would get back to us about next steps. A month and a half later, we received a letter from the lawyer stating he would not be moving forward with the case due to the amount of the opposition the medical panel's opinion would give, and he was not willing to take the financial risk. We were once again at a loss, almost having to relive a grief process. Everywhere we turned, we were getting no assistance. After a couple of weeks, we tried to find another lawyer to take on the case, but soon discovered our case was now past the statute of limitations. As the law states now, you have only 90 days to file a case once the panel renders an opinion. This was never stated to us from our lawyer, and in fact, when we received the letter from the lawyer stating we would not continue with the case, we only had 10 days to find another lawyer to take on the case. Not a long amount of time with a case with so much opposition from the panel. However, we didn't even know this deadline existed. Bringing us to where we are today, we have gone down every possible avenue to try to get justice, just a sliver of help in this journey. This bill before you was created as a possible solution to the issues we faced while going through this process. We are not just coming to you because we read the Medical Malpractice Act in Louisiana or read about the panel. We are people that actually have gone through the process. And we've seen the roadblocks, the weaknesses in the system, and in many ways the protection it only provides for the medical community when the process is supposed to exist as a fair process for both parties involved. I know the focus of this bill will revolve around the proposed changes on the cap of the recovery of the medical malpractice cases. While that is important, it is my hope you will see the need to allow for more time for documentation to be collected, submission of a case to be extended, and to allow for a claim to have a chance at a fair and unbiased opinion from a medical review panel. To highlight some of the changes this bill proposes, I would ask you pay attention to a couple of the changes. One of those being that the current law requires that all medical review panelists, with the exception of the attorney, be individuals from the same class or specialty of practice as the defendant healthcare provider. We are suggesting the composition of the medical review panel be like that of a jury, to require that no more than one of the panelists be from the same class or specialty of the defendant position, including they did not go to school with, have not worked with, and do not live within a 100-mile radius of the physician in question. We understand the need for there to be a voice at the table that has experience in the specialized area as the defendant, thus allowing one of the panelists to be of that specialty. Secondly, we are suggesting you separate economic and non-economic recoverable damages in medical malpractice claims with a $350,000 cap on non-economic damages, and economic damages be limited to the actual cost of past, future medical care and related benefits. Louisiana is one of 35 states regulating caps on medical malpractice compensations. However, 31 of those 35 states with these regulations only cap non-economic damages, meaning compensation for pain and suffering, emotional distress, or loss of life, or loss of enjoyment of life, ranging anywhere from $250,000 to $2.25 million. Only 4 states limit overall damages, including economic damages, meaning the actual cost of the medical care. Louisiana is one of those states and has the lowest cap of $500,000. We are suggesting to separate the two damages as it provides the opportunity for individuals affected by medical malpractice or their family to actually be compensated to cover their medical expenses and pain and suffering. The total amount claimants pay on medical bills is many times close to the actual amount they are awarded, not leaving any room for compensation of non-economic damages. The New Orleans Times-Picayune reports in 2013 only 1 out of every 8 medical malpractice cases in Louisiana were awarded compensation, with a total of 276 cases awarded for that year. The compensation of those 276 cases was $101.8 million, averaging about $365,000 per case. Many times, medical bills in an actual medical malpractice case are over these amounts, and claimants are not fully restored to the bills that they had to pay for a failed medical service. I equate this to something as simple as buying a product from a department store. You take it home, open the container, you find it's broken. What do? You take it back to the store and you're refunded what you paid for it, nothing more, nothing less. Why would that philosophy be any different for a human life? Why would that philosophy be different for a human life who's experienced a failed case of medical service? This bill would allow for the claimant to be fully restored the actual cost of the care provided under the failed care, and then the courts could decide on an amount the claimant could receive for non-economic damages with a cap. If you hear nothing else from this section, please hear this. The $500,000 cap was implemented in 1974 and has not been increased since. Basic economics explains the need to increase this cap based on inflation and economic values. A reform of this bill must occur. It's time. Lastly, the bill provides opportunity for claimants to get the required materials in and to have a case reviewed. As the law stands now, claimants have a stringent time frame from 6 months to a year to 3 months, depending on what the circumstances in the process. However, when hearing these time frames, it might sound like a long period of time to accomplish these tasks. But when you're dealing with individuals who have severe traumas from medical malpractice or grief-stricken families who have to deal with the loss of a loved one, I promise you it's not. And on top of the time it takes for law offices to file and gather paperwork. Then compare that to the time restraints put on the claimant against the non-existent time restrictions on the medical review panel. It's a necessary change. We are not asking for unrealistic changes in the time frame. Where the bill currently lists 90 days, which is 3 months, we're suggesting 6 months. Where the bill states 1 year to file a claim, we're suggesting 18 months. This is a system that's really backwards. You have to go through a process to get permission to sue, and then if the medical community okays it, you are then subject to a cap set over 33 years ago. It's time to reevaluate the practices and processes of this bill. I know this can be a controversial topic, but let's break it down to why it's controversial. Because of the almighty dollar. If this bill were simply dealing with the well-being and betterment of inanimate objects, then I could understand the fight for the dollar. But that's not the case here. We're dealing with human lives, real people. We are dealing with people like Phoebe Shadd, who deserved better care, and who would want for those who are unfortunately to face medical malpractice or neglect in the future to have a fair opportunity to receive restoration. Before you vote yes or no, put an actual face of a loved one attached to that yes or no. Would you want that loved one to have an opportunity to receive a fair chance at getting restoration? Would you not want the proper time to grieve your loss and have time to file a claim to a fair process? As someone who's experienced this process firsthand, I can promise you the answer is yes. And if you can't think of a loved one's face to attach to your answer today, I'll gladly show you Phoebe's.